Federal Judge Patricia Hernandez of the D.C. Circuit just issued an emergency restraining order that effectively suspends Congress from conducting oversight hearings for the next 30 days. Not because of national security concerns, not because of procedural violations. The judge said it herself in her written order. The legislative branch has exceeded constitutional boundaries and threatens irreparable harm to executive function. I am Elizabeth Carter, and this is independent investigative journalism. Before we go any further, I need you to do something right now. Hit that subscribe button, click the notification bell, leave a comment below telling me whether you have noticed increasing judicial intervention in politics over the past year. Share this video with everyone you know. This is the only official channel. Beware of imitators trying to copy this style and steal your trust. What I am about to show you is happening in real time across Washington, D.C., and it is spreading. This ruling came down at 11:47 p.m. on January 4th, 2026, after emergency filings from White House counsel. Think about that timing. Late Friday night when most Americans are asleep and Congress is in recess. Not during normal business hours when the full legal press could respond immediately. At 11:47 p.m. when the news cycle is dead and oversight committees cannot convene emergency sessions. Here is the core argument tonight in plain language. A single federal judge just declared Congress constitutionally powerless to investigate government corruption. This is not about partisan politics. It is about the fundamental structure of American government being rewritten by one person in a black robe. Tonight, I am going to walk you through exactly how this unprecedented ruling happened, who benefits from congressional paralysis, and what this means for every investigation Congress has planned for 2026. Let me tell you what this ruling actually says. Judge Hernandez wrote that congressional investigations which parallel criminal inquiries create dual jeopardy concerns for executive branch officials. Translation: if Congress might find evidence of crimes committed by government officials, Congress is not allowed to look. The executive branch gets a constitutional shield against accountability as long as there is any possibility their actions were illegal. Think about that legal logic for a moment. The more corrupt government officials are, the more protection they get from congressional oversight. The ruling creates a perverse incentive where criminal behavior by public servants actually strengthens their legal immunity. And here is what nobody is saying out loud. This is not the first time Judge Hernandez has ruled in favor of protecting government officials from congressional scrutiny. The investigation that triggered this constitutional crisis started with a simple question from the House Oversight Committee. Why did the Defense Department award $47 billion in contracts without competitive bidding in 2025? The answer they found has powerful people terrified of congressional scrutiny. Pentagon Procurement Officer Sarah Chen was scheduled to testify before Congress on January 6th about systematic contract manipulation within the Defense Department. Chen has worked in defense procurement for 12 years. She knows how the system is supposed to work, and she knows exactly how it has been corrupted. Here is what Chen discovered. Defense contractors with personal connections to Defense Secretary Michael Harrison received no-bid contracts worth billions, while qualified competitors were excluded from the process entirely. Chen documented 23 separate instances where Harrison personally intervened to award contracts to companies where he had financial stakes. Sarah Chen told House investigators during her pre-testimony deposition, these were not emergency procurements. These were not sole source contracts due to national security requirements. These were deliberate manipulations of the procurement system to benefit specific companies with personal connections to senior leadership. Let that sink in. The defense secretary was using his official position to direct taxpayer money to companies where he had financial interests. Chen had the documentation to prove it. Bank records, emails, contract modifications, and meeting transcripts showing Harrison directing procurement officers to favor connected contractors. The evidence chain Chen assembled shows three distinct patterns of corruption. First, domino. Harrison would identify upcoming procurement opportunities through classified briefings. Second domino. He would share contract specifications with preferred contractors before official announcements. Third domino. Those contractors would submit bids perfectly tailored to win, while legitimate competitors bid on incomplete information. But here is where this story becomes a constitutional crisis. When Congress issued subpoenas for Defense Department communications about these contracts, the White House claimed executive privilege over all Defense Department correspondence, not just classified materials, not just sensitive operational details, every email, every memo, every text message related to these contracts. Congressional leadership pushed back immediately. House Speaker Maria Rodriguez told reporters, executive privilege cannot become a blanket shield for criminal activity within the executive branch. Congress has a constitutional duty to investigate potential corruption, and no privilege claim can override that responsibility. The White House response escalated the conflict beyond normal executive privilege disputes. White House counsel filed emergency motions arguing that congressional oversight had become prosecutorial in nature and violated separation of powers principles. Translation: Congress cannot investigate government corruption if that investigation might reveal criminal behavior by government officials. Constitutional law professor David Martinez at Georgetown University warned that this interpretation eviscerates the separation of powers system. Martinez told legal journalists, if Congress cannot investigate potential crimes by executive officials, then the executive branch becomes legally accountable only to itself. That is not constitutional government. That is authoritarian immunity. Think about what the White House legal brief actually claims. Congressional subpoenas are invalid if they seek evidence of executive branch wrongdoing. Congressional hearings are unconstitutional if they embarrass administration officials. Congressional oversight powers disappear the moment they become effective at uncovering corruption. And it gets worse. The emergency court filing that led to Judge Hernandez suspending congressional oversight was submitted at 8:30 p.m. on January 4th. Congress had no advance notice. House Oversight Committee staff learned about the court hearing from news reports after the restraining order had already been issued. The emergency court hearing that paralyzed Congress happened at 9 p.m. on January 4th, with only 30 minutes notice to congressional counsel. Think about that timeline. White House files emergency motion at 8:30 p.m. Court schedules hearing for 9 p.m. Congressional lawyers get notified at 8:30 p.m. and have exactly 30 minutes to prepare a constitutional defense of legislative oversight powers. Judge Patricia Hernandez presided over this constitutional crisis hearing. Hernandez was appointed to the D.C. Circuit in 2019 after spending 15 years as a corporate defense attorney specializing in government contract disputes. Her client list included 3 of the largest defense contractors in America, the same defense contractors now protected by her ruling against congressional oversight. Here is the exact language Judge Hernandez used to suspend congressional power. Congressional investigations that parallel criminal inquiries create dual jeopardy concerns for executive branch officials and violate fundamental due process protections under the Fifth Amendment. Such investigations exceed the constitutional scope of legislative authority when they assume prosecutorial functions properly reserved for the judicial branch. Translation: Congress cannot investigate government corruption if that corruption might also be criminal. Any congressional hearing that could embarrass executive branch officials with evidence of wrongdoing is now constitutionally prohibited. The more corrupt government officials are, the more legal protection they receive from accountability. Congressional representatives were not allowed to speak during this emergency hearing. House Speaker Maria Rodriguez issued a statement immediately after the ruling. We just watched a federal judge declare Congress constitutionally powerless to do its job. This ruling makes congressional oversight conditional on executive branch approval. That is not separation of powers, that is executive supremacy. Let me walk you through what this ruling actually means in practice. The House Oversight Committee has active investigations into 12 different cases of potential government corruption. The Senate Judiciary Committee is investigating Department of Justice misconduct in 14 cases. The House Armed Services Committee is examining defense contractor fraud in 8 ongoing cases. Under Judge Hernandez's ruling, all 34 investigations are now constitutionally prohibited. Think about that scope. 34 congressional investigations into government wrongdoing stopped by one emergency court order, every subpoena voided, every scheduled hearing canceled, every whistleblower silenced. One federal judge just granted the executive branch immunity from legislative accountability across the entire federal government. Here is what makes this ruling legally unprecedented. Federal courts have never suspended congressional oversight powers through emergency injunction. Even during Watergate, even during Iran-Contra, even during the most extreme executive privilege disputes, no court claimed authority to prohibit Congress from investigating executive branch corruption. Former federal prosecutor Jennifer Walsh analyzed the ruling for legal publications. This decision essentially makes congressional oversight conditional on executive branch consent. If the president claims an investigation embarrasses his administration, federal courts can now block that investigation as unconstitutional. That transforms our system from constitutional democracy to executive autocracy. The timing of this restraining order is not coincidental. The order specifically expires on February 5th, which is exactly 1 day after Defense Secretary Harrison submits his scheduled resignation. Translation: congressional investigation of defense contract corruption gets suspended until the main target of that investigation leaves office and cannot be held accountable. And here is the irony that should make everyone angry. This emergency order to protect executive function from congressional interference actually paralyzed legislative function instead. Judge Hernandez ruled that protecting one branch of government from embarrassment justifies suspending another branch from performing its constitutional duties. But wait, there is something the court did not disclose during this emergency hearing. Judge Hernandez's financial disclosure forms show her husband works for Morrison, Kellerman and Associates, a Washington law firm that represents defense contractors. Specifically, the firm represents 3 of the companies under congressional investigation for the no-bid contracts that started this entire constitutional crisis. Let that sink in. The judge who suspended congressional oversight to protect defense contractors from investigation has direct family financial ties to the legal defense of those same defense contractors. And nobody mentioned this conflict of interest during the emergency hearing that dismantled congressional power. Let me tell you about Sarah Chen, Pentagon procurement officer for 12 years, mother of 2, the person who risked her career to expose systematic defense contract corruption. Sarah Chen told me during our interview, "I risked my career to expose this corruption, and now the courts have silenced the only people who could act on it. I have boxes of evidence proving billions in fraudulent contracts, and Judge Hernandez just made that evidence legally irrelevant." Sarah is not alone in this constitutional exile. Michael Torres has worked as a House oversight investigator for 15 years. He has built corruption cases that returned hundreds of millions in taxpayer money. Torres described his current situation. "We have boxes of evidence sitting in locked rooms. The court order means we cannot even brief committee members on what we found. 15 years of investigative work just became legally worthless overnight." Think about what that means for government accountability. Congressional investigators who spent months building corruption cases cannot share their findings with the people who hired them to investigate. Evidence of criminal wrongdoing sits in locked filing cabinets because a federal judge decided Congress has no right to see proof of executive branch crimes. Now let me tell you about Rebecca Martinez. She leads a disabled veteran advocacy group that represents soldiers injured by defective equipment. The same defense contractors under congressional investigation supplied body armor that failed in combat zones. Rebecca Martinez told veteran families at a January meeting these contracts were supposed to improve protection for our troops. Instead, the money went to executive bonuses while soldiers got equipment that failed when they needed it most. 3 soldiers died in Afghanistan when their body armor failed to stop rifle rounds it was designed to block. The armor was manufactured by Blackstone Defense, one of the companies that received no-bid contracts through Defense Secretary Harrison intervention. The congressional investigation Sarah Chen triggered was supposed to examine whether cost-cutting in those no-bid contracts led to equipment failures that killed American soldiers. Now that investigation is suspended, the families of those 3 soldiers will never get congressional hearings into whether corruption in defense contracting contributed to their sons' deaths. Judge Hernandez's ruling means those families cannot even get access to procurement records that might explain why inferior armor was approved for combat use. Let that sink in. Military families who lost sons to defective equipment cannot get justice because congressional investigation of that equipment violates executive privilege. The court system just told Gold Star families that protecting defense contractor profits matters more than accountability for equipment that failed their children. James Wilson owns a small defense contracting business in Ohio. For 3 years, Wilson submitted competitive bids for armor plate manufacturing contracts. His company had the lowest prices and highest quality ratings. Wilson told congressional investigators, "I played by the rules, submitted competitive bids for 3 years, then watched connected companies get handed contracts without even bidding. My business lost 2.3 million in contracts that went to companies with half our quality ratings." Wilson Business employed 47 people manufacturing armor components. When the no-bid contracts went to connected firms, Wilson had to lay off 32 employees. Those families lost health insurance, retirement savings, and career stability because the procurement system was rigged to favor politically connected contractors over qualified competitors. And James Wilson is not alone. Congressional investigators documented 17 small businesses that lost defense contracts to no-bid awards given to connected firms. Those 17 businesses employed over 600 people. Most of those jobs disappeared when contracts went to politically connected companies instead of competitive bidders. Here is what the constitutional lawyers are saying about this human cost. American Bar Association Constitutional Committee Chair David Cheng issued a statement calling the ruling an unprecedented attack on legislative authority. Chang told legal reporters, "When courts block congressional oversight, the victims are not just representatives and senators. The victims are every American who depends on government accountability to protect their interests." Chang pointed out the broader implications for democratic governance. Constitutional law expert Sarah Kim at Harvard explained to policy journalists, "This ruling creates a protection racket for government corruption by making congressional oversight illegal. Every whistleblower, every victim of government misconduct, every taxpayer who demands accountability just lost their primary avenue for seeking justice." And here is the pattern nobody wants to acknowledge. Sarah Chen is not the only Pentagon whistleblower requesting congressional protection that cannot be provided. Marcus Rodriguez exposed Air Force contract manipulation in November. Jennifer Walsh documented Navy procurement fraud in December. David Thompson revealed Army contract violations in January. All four whistleblowers requested congressional hearings to present their evidence. All four now face career retaliation with no congressional protection available. Judge Hernandez's ruling did not just suspend legislative oversight, it suspended the primary protection system for government employees who expose corruption. Here is what Judge Hernandez's ruling means for the future of American democracy. If this precedent stands, any executive branch official can claim congressional oversight threatens their executive function and request court protection from legislative accountability. Translation: congressional oversight becomes constitutionally impossible whenever it embarrasses government officials. This is not about politics. It is about math. Congress investigates roughly 200 cases of potential government misconduct every year. Under Judge Hernandez's precedent, executive officials can block any investigation that might reveal embarrassing or criminal behavior. That means 200 accountability mechanisms disappear overnight if this ruling becomes legal precedent. Watch the domino effect this creates across government. First domino: Defense Department investigations blocked to protect corrupt contracting. Second domino: every cabinet department claims the same constitutional protection from congressional oversight. Third domino: congressional oversight becomes legally impossible whenever it threatens to expose executive branch wrongdoing. The timeline for this constitutional collapse is terrifyingly short. Appeals court hearing is scheduled for January 8th. If the D.C. Circuit upholds Judge Hernandez's ruling, every federal court in America gets legal precedent to suspend congressional oversight powers. Constitutional law professor Jennifer Kim at Harvard warned legal scholars, "We could have a complete breakdown of legislative accountability within 30 days. Think about what that means in practical terms. Department of Education cannot be investigated for mismanaging student loan programs. Department of Health cannot be investigated for pharmaceutical approval corruption. Department of Homeland Security cannot be investigated for immigration enforcement violations. Every executive department gets constitutional immunity from congressional scrutiny. Here is the historical context that should alarm everyone. No federal court in American history has suspended legislative oversight powers to protect executive branch officials from embarrassment. Not during Watergate, when President Nixon claimed executive privilege over criminal evidence. Not during Iran-Contra, when President Reagan claimed national security exemptions. Not during any constitutional crisis in 247 years of American democracy. Former Supreme Court clerk David Martinez explained the dangerous precedent to constitutional scholars. This ruling creates judicial veto power over legislative function. Federal judges can now determine which congressional investigations are constitutionally permissible based on whether those investigations embarrass executive officials. That transforms separation of powers into executive supremacy protected by judicial enforcement. And it gets worse. Remember Judge Hernandez's financial disclosure showing her husband law firm represents defense contractors under investigation? That conflict of interest pattern extends beyond this case. 3 other federal judges hearing executive privilege disputes have spouses working for firms that represent government contractors or executive branch officials. The legal community is starting to recognize this systematic problem. American Constitutional Law Association President Sarah Walsh issued a statement warning about judicial conflicts in executive privilege cases. When judges with financial ties to executive branch interests rule on executive power disputes, the appearance of corruption undermines public confidence in constitutional governance. Translation: the court system protecting executive officials from congressional accountability includes judges with personal financial stakes in those protection decisions. We have judicial corruption protecting executive corruption from legislative accountability. Constitutional checks and balances are being systematically dismantled by people who profit from the dismantling. Here is what constitutional experts are warning about the timeline. If appeals court upholds this ruling on January 8th, Supreme Court review could take months. During that time, every congressional investigation of executive misconduct remains suspended. Every whistleblower remains unprotected. Every accountability mechanism remains paralyzed while government corruption operates without oversight. Harvard Law constitutional scholar Rebecca Kim told policy analysts, "This creates a judicial protection racket for government misconduct. Executive officials commit crimes, claim congressional investigation violates their constitutional rights, and federal courts with financial ties to those officials block accountability. That is not constitutional democracy. That is systematic corruption protected by legal immunity." And here is the warning projection nobody wants to say out loud. If congressional oversight can be suspended to protect defense contractor profits, it can be suspended to protect any government corruption that embarrasses executive officials. Environmental violations, financial fraud, civil rights abuses, election interference. Every form of government misconduct gets constitutional protection from accountability if this precedent stands. Here is the accountability question I want you to answer in the comments. Should a single federal judge be able to suspend Congress from investigating government corruption? Comment yes if you think courts should protect executive branch officials from congressional oversight when that oversight might embarrass them. Comment no if you think Congress must retain constitutional power to investigate misconduct regardless of who gets embarrassed. This is not a theoretical question. The appeals court hearing happens January 8th at the D.C. Circuit Court of Appeals in Washington. You can attend that hearing. You can contact your representatives and demand they speak out against judicial suspension of congressional oversight. You can demand judicial accountability when judges with conflicts of interest rule on cases that benefit their financial interests. I will be documenting every stage of this appeals process. Subscribe to this channel and hit that notification bell so you do not miss updates on whether American democracy survives this constitutional crisis. Share this video with everyone who cares about democratic accountability. This story affects every American regardless of party affiliation because this is about whether government officials can be held accountable for corruption. This story is not over. It is being written right now in federal courtrooms and congressional offices across Washington. The outcome depends on whether enough Americans demand that constitutional checks and balances survive judicial attempts to dismantle them. Because this story is not about politics, it is about whether we still have a democracy where power answers to the people. Leave your thoughts in the comments below. Tell me whether you think federal judges should have power to suspend congressional oversight. Tell me whether you think government corruption should be protected from legislative accountability.